Today we're fortunate enough to have Robert Freeman from the Committee on Open Government at the State of New York. Bob Freeman has been Executive Director of the Committee on Open Government since 1976. And this is a position that is, I guess, not uniquely important, but quite important in freedom of information circles, because although freedom of information laws are common in the United States and even around the globe, it's less common to have what we have here in the state of New York, which is an office dedicated to the study and administration of that law. And Mr. Freeman, in his role of Executive Director, not only has taken the lead in the development of this office, but also in the development of this law and its revisions in the state of New York, and has served as a consultant on freedom of information matters around the United States and around the globe. So his expertise is widely recognized. He has a law degree from New York University and a BS Foreign Service from Georgetown University. He, over the course of his distinguished careers, has received accolades and honors from organizations too numerous to mention. And that is not euphemistic, that's actually just true. There are too many things here for me to mention. We are thrilled to have him here with us today. The title of his talk is Freedom of Information, the Legacy and the Future. As is our practice, we will proceed until 5 o'clock today, after which there will be a reception. The food will be coming right into the room at 5 o'clock, and that'll be an opportunity to continue conversation with our speaker. Please join me in welcoming Bob Freeman.
Thank you. First of all, it's an honor and a great pleasure to be here. I just found out about this program when Professor Gutterman sent me a note and indicated that it was law, politics, and the news media. Wow, and bringing together students from three graduate programs, and undergrads too, I would imagine, within the university. What a terrific idea. I don't know whose idea it was, but from my perspective, it is absolutely impossible to separate those three areas of concentration. And what I'd like to do during the course of our discussion today is attempt to relate one to the other. But what I'd like to do first is find out who you are, which school you attend, maybe even a little bit about why you're here, where you're from. Let's start off, I suppose, in the back of the room. Can we?
I'm in a law program.
Uh-huh.
Where I'm from.
Yeah, sure.
Right now,
Not right now. Where did you grow up?
all over the military camp.
Okay. The reason I ask is because the laws are different in every state in the United States. They're different throughout the world, and often we can compare your experience in wherever as opposed to ours in New York, for example, or the United States, as the case may be. So you're from nowhere, essentially.
Pretty much.
Okay.
I'm in a law program. I'm from Metro Detroit, and I'm in this class because media law is what we want to go to law school.
Great.
I'm from Rochester, New York, and I'm in the law program.
Uh-huh.
And
So do all the lawyers sit together? Is that it? No?
We usually sit there.
Just a good
sit in
one.
our seats.
Uh-huh. And let me guess, you're from Vermont.
Vermont.
Oh, yeah.
Flamboyant.
I can tell. I can tell.
Yeah, also too well in the law program from
Good.
I'm actually in the broadcast journalism program.
Great.
Undergrad. I'm from Buffalo.
Uh-huh.
And I'm going to law school next year.
You are? Huh. So you'll combine the two. Do you want to go into media law?
I actually don't want to do anything with communications. It was still a fun major.
Well, then the question is, what the hell are you doing here?
Too late to change.
It's too late to change. Okay. You may change your mind about that, too.
I'm from China,
Where in China?
northeast, near South Korea.
Uh-huh.
And I'm in public relations in community school here and in international relations as well.
How great.
I'm a camera guy.
You're the camera guy.
But I'm a broadcast journalism major.
Okay.
Nothing to do with the
So you're getting paid to be here, is that it?
Yes.
Okay. Well, there are all kinds of reasons for being
And I
here.
like the food at the end.
Are you a student too?
Yes. I'm still learning.
Student of life. Okay, well, I'm glad you're here.
I'm a 2L here at the law school.
Uh-huh,
Delaware.
okay. A blue hen.
I am a non-matriculated student from Maxwell.
Uh-huh.
But my undergrad was in social science and sociology.
And where was that?
University of Colorado.
Colorado, same as Shannon, right? Yeah. Huh.
My name is Trey. I'm a fourth-year sociologist today.
Uh-huh.
And I was also a military child. I spent 8 years in Colorado, so.
Hmm.
I'm from Tucson, Arizona. I'm a master's student in Newhouse for broadcast journalism.
Uh-huh.
And I'm also at law school.
You are. What is this, this journalism law school thing? Is this common now?
I was doing undergrad.
Really? Huh. Where was that? Here at Syracuse?
University of Connecticut.
University of Connecticut. So you stayed in the Big East anyway. Unfortunately? Well, I don't know about that. I do know quite a few journalists who have gone to law school. And I think it's a good thing if you have a focus. Certainly if your area of interest is the environment, studying environmental law in law school takes you a long way toward accomplishing what you set out to do in your career.
I'm a public relations major
Mhm.
over at Newhouse School.
Mhm.
And I'm originally from Taipei, Taiwan.
Great.
I'm a 3L at the law school and I'm from California.
Uh-huh. Why did you come to Syracuse? I'm just curious. The weather?
The snow.
I mean, is that it?
Seems like fun.
Huh. And has it been?
It's been so much fun.
Okay, well,
So beautiful.
is she known for her veracity? Just kidding. See, my kid went from the Northeast to San Francisco. That's what he says.
Hi, my name is Don Trey. I am a graduate student at Newhouse in broadcast journalism.
Uh-huh.
And I'm originally from New Orleans, but I now live in Manhattan.
Now you live in Manhattan, so you
Right.
commute?
Well, no, I mean, I don't consider this my permanent residence.
Oh, okay.
But I'm here
Okay.
for school, and no, I'm not liking it.
Uh-huh,
The
no.
school, yes.
But the weather, no.
Syracuse, and
Syracuse,
not
no.
so much.
Okay. Well, Manhattan is pretty great, though, anyway.
Yeah.
Nothing like it.
I'm Ann Woodland. I'm from the real world. I'm an activist and citizen of Onondaga County,
Uh-huh.
and you have had several conversations in recent years.
If you tell me, I believe you. Thank you for coming. Yes.
I'm a 2L at law school, and I'm from Philadelphia, Pennsylvania.
I'm actually a dual degree student, so I both with law school and with Maxwell.
Wow.
Doing a master's in political science there. And I'm from Potsdam, New York.
Uh-huh. Speaking of cold.
Yeah.
Yeah, but it's a beautiful little community.
I'm an alumni, and I love to play piano with my...
So you're in the right place. Yeah.
But I am also very interested in helping the environment, like I was helping with Obama's campaign to pass the health care, and now I want to work on preventive medicine, in particular interested in finding out how we can get color dyes and also mercury out of vaccines.
I'm not sure that I can help you today, but thanks for coming anyway. Yeah.
I am a third-year law school, or law student, and I'm from the west of Cleveland, Ohio.
Uh-huh.
I'm a political science at Maxwell. I'm a master's student continuing into public administration. I'm actually somewhat local. I live in Norwich, New York, about an hour away.
I know where it is, sure.
Very small.
We've met.
I'm a law student. I'm originally from Denver.
Great. Shannon, you're part of the program too, aren't you?
Yeah, well, yeah, but not technically part of it. I'm a 2L. I'm from Colorado.
We seem to have a preponderance of people from Colorado here today. Yay, buffaloes.
Representing.
Yeah.
My name is Ross. I go to law school. I'm from Syracuse.
Uh-huh. So you stayed close to home or came back?
Sure.
I'm from Turkey.
Uh-huh.
I teach Turkish at SU.
Uh-huh.
So.
And are you part of the program, or you're just here? For the
I'm a
knowledge
Fulbright
part.
teaching assistant, so I'm required to take 2 classes each semester. So.
So you got sacrificial.
Genuine love is a subject.
But it's interesting, but I do not. I know.
Turkey. I hope to travel to Turkey someday soon.
Yeah, you should.
I'd like to.
I'm a graduate student studying documentary film and history, so I study at both Newhouse and Maxwell, and I'm from Tucson, Arizona.
You're also from Arizona, huh?
Yeah.
Gee, did you guys know each other before then? No. So now you will. Yes.
I'm Liz. I'm from Kansas City. I'm a grad student in media studies at UMass.
Missouri or Kansas?
Missouri.
Missouri, okay, big ones. And that's it, right? Okay. Again, my name is Bob Freeman. I should give you just a little bit of an introduction. Again, I work for a tiny agency within the New York State Department of State called the Committee on Open Government. I say tiny. The staff at full strength is 3 of us. We are the smallest state agency that actually does anything. I'll leave the rest to your imagination. And I have what I've considered forever, or so it seems, to be the best job in state government. In all honesty, I am mystified often that they pay me to do what I do. And all we do all day, every day, is give advice, legal advice, to anybody who has a question about what's public and what's not. Primarily in relation to 3 laws in New York, our Freedom of Information Law. How many of you have heard of it as FOIL? FOIL. Yes, it's become part of the language in New York. We also deal with the state's open meetings law, as well as the personal privacy protection law. And when I suggested a moment ago that we give advice to anybody, I mean exactly that. We take loads of inquiries from every sector of society. People from state government, local government, members of the news media, members of the public. It doesn't matter. Our only goal is to give what we believe to be the right answer under the law, irrespective of who asks the question. So we're not there to support the government. We are there to do the right thing. And I'm not suggesting that those two are necessarily mutually exclusive, although some people tend to think that that is so. We write advisory legal opinions. Anybody here visited our website? Nobody? A few people have visited the website. We are really easy to find. We're the only committee on open government in the world. So if you just Google COOG, you'll get there. And we have a tremendous amount of information that's available online. The text of the law, frequently asked questions, an annual report which includes recommendations. Am I driving you crazy?
Keep doing what you're doing. Doesn't matter.
Recommendations to improve the operation of open government laws in New York. We also write opinions we've written over the course of years in the neighborhood now of 23,000 opinions. They are indexed by key phrase. One index deals with the Freedom of Information Law, the other the Open Meetings Law. They're intuitive kinds of indices. So if you have a question, for example, under the Open Meetings Law about notice to the news media, you would go to the Open Meetings Law listing, click on to end, scroll down to notice to the news media. And our opinions prepared since 1992 are available online in full text. So someday when you're practicing law perhaps, or a working journalist, and you are at least a little bit obsessed, you can go to the website at 3 in the morning and find, in all likelihood, what you need. I encourage people to call. We are on the phone frequently. We get thousands of calls every year. And for you journalists, I am always on the record. I don't care who I upset. The reality is that there are many, many, many instances in which reporters call knowing what the answer is. But after all, you can't print your own opinion. You call me for the quote. And I have absolutely no hesitation about giving it. So there we have a simple situation in which the law and politics and the news media come together. And that is simply the case in any number of circumstances. The law, I give an answer that's based upon the law. Politics, because, let's face it, members of the news media call in relation to some issue pertaining to government, and therefore politics. And of course, third, the news media using me and using the law in a way in which they can tell the world more appropriately what's going on, or what may not be going on, as the case may be. I am here for you, so I encourage you to ask questions throughout. I can talk about this stuff from now until hell freezes over if you let me. But if you do, we'll miss the issues that are really perhaps important or troubling to you. So I invite you to fire away anytime. Any questions? Yeah?
Why is there this preponderance of having to go and get some sort of a written approval to get something?
A written approval to get a record?
Yes, to get a record.
Stop. Not so. Not so necessarily. Many of you, how many of you have been working journalists? A few. My guess is that you covered units of local government for the most part. Is that accurate? Yeah? Yes? No? Well, often, and especially, you know, after you get your master's at Newhouse, maybe you'll go into broadcast, maybe you go into print. If it's real journalism, chances are pretty good it'll be in a relatively small community, at least as a starting place. If you walk into your town clerk's office and ask for the minutes of last month's meeting, my guess is that the clerk is going to say, sure, they're over there. They're over there. No need for a written request. FOIL permits a government agency to require that a request be made in writing, but certainly, especially at the local government level, often people get what they want simply for the asking. You can walk into a government office and often simply get it. Secondly, and I was going to discuss this later, but I believe that we are involved in a trend. We are involved in a trend. And the trend deals with what we characterized in our reports to the governor and the legislature about 3-4 years ago as proactive disclosure. And I don't know how many of you might have read President Obama's directive to federal agencies the day after he took office. A significant element of that directive involved what he called proactive disclosure. Now, I don't know whether that's a commonly used term or whether he took it from us. In any case, it involves the situation which is arising all the time these days, in which the government places records on its website. And we see that in Washington, we see it in state government, we see it in local government as well. And the notion is really quite simple. When a government agency finds out that certain kinds of records are clearly public and frequently requested, what do? They put them on their websites. And that is what I describe as a win-win kind of situation. Why? Nobody has to make a request in writing. The records are simply there for the taking. And from the government's point of view, and this is how I've tried to sell it, and I think that people in government are actually buying it, when the records are posted online, nobody in the government has to deal with a Freedom of Information request. Nobody has to go to the filing cabinet and locate and pull out paper. Nobody has to stand at the photocopy machine. Nobody has to do the administrative tasks associated with taking in whatever it may be, a quarter per photocopy. So again, if there's any trend at all that we see, at least for the future, it is proactive disclosure, it is government placing records on their websites, which eliminates the need in so many instances for having to make requests. Yeah.
I realize this is...
Mr. Vermont.
Yes, Mr. Vermont.
Or Mr. Ithaca.
Mr. Universe.
Yeah.
So this is against the trend of proactive disclosure, but could agency require an advisory opinion for every disclosure if they wanted to?
You mean from my office?
Yeah, like could
and
they say...
require an advisor? No.
No, so
No.
That never
No,
happened.
as a matter of fact, some of you probably have read about experience under the Federal Act, where, in fact, I had a letter on my wall, which was dated 2005 or something like that, and it involved a request that was made to a federal agency in 1994. And the federal agency, 11 years later, wrote back to the person who made the request and said, "Are you still interested? We still haven't gotten to it yet." There are terrible delays that people have faced in using the Federal Freedom of Information Act. Now, I'm not going to suggest that our law is perfect or that agencies abide by the law all the time, but as a general rule, in New York, when you submit your request, the agency has 5 business days to respond. Now, it can extend the time, but it can't go on and on and on and on and extend it forever. When it does, that is considered a denial of your request. That gives you the right to appeal to the head of the agency. And if that person or body doesn't respond within 10 business days, you can go to court if you want to go to court. And in New York, if you do go to court, and in the words of the law, if you substantially prevail, the court can award you attorney's fees if either the agency had no reasonable basis for withholding the records, or if the government agency dragged its feet and failed to abide by the time limitations that are imposed by law. So nobody has to seek an advisory opinion from us, but anybody may. Anybody may. And again, the advisory opinions, thousands of them are available online. The hope, of course, is that they encourage compliance. They are used to enable people to become knowledgeable. The hope, of course, is that they are persuasive. And often they are used as a means of avoiding the necessity of going to court. Does that answer your question?
Yeah.
More questions? Student. Yeah.
In your piece, you said that
My piece.
in the committee's piece,
Yeah.
you said that the courts aren't necessarily subject to FOIL,
The courts are not subject to FOIL.
but could you kind of explain how
Sure.
access to court records
Sure.
mesh
Sure.
with FOIL?
Anybody here know about, what's it called, First Amendment? First Amendment. You know, as I understand the interpretation of the First Amendment, there is only one aspect of the First Amendment that provides access to government information, and that is a First Amendment right in general to be present at judicial proceedings. Now, in New York, and this is true under the Federal Act and most state laws, the courts are not covered by the Freedom of Information law. Why? Because there are so many other provisions of law that deal with the courts and court records that the Freedom of Information law simply would have no impact. And in New York, generally speaking, we should assume that we can walk into a courthouse and obtain practically whatever may be maintained by the clerk of a court. So FOIL is largely irrelevant to court records. Yeah.
In the same section of your brochure?
Yes.
The second paragraph says, agencies charged with responsibility of administering the judicial branch are not courts and therefore are treated as agencies.
Correct.
Subject to FOIL, so that uniform court system.
Yeah, the Office of Court Administration. Yeah, you know, I wrote an opinion around 1980. They said, we're a court, and I said, I think you're an agency. You don't decide cases. You simply oversee and administer the judicial system. And amazingly, the Supreme Court and the Appellate Division both agreed and said, yep, and the handwriting was on the wall. They were the Appellate Division decision was unanimous. So it's been crystal clear that the agency that administers the court system is itself not a court and therefore is subject to the Freedom of Information law. For what it's worth, for journalists and attorneys, the courts often are a treasure trove of information. You know, there are exceptions in access laws that deal with protection of personal privacy, and we'll talk about that more later, I'm sure. But gee, you walk into a courthouse, you get all kinds of personal things simply because they are filed there. Bankruptcy court, you get a tremendous amount of personal information. There are, I have to suggest to you, areas of court records that are out of bounds. For example, in New York, records involving matrimonial proceedings are out of bounds. Records that identify victims of sex offenses are confidential by statute. So there are some exceptions, but in the scheme of things, they are relatively rare. Does that help you?
I've just had particular difficulty with the Syracuse courts themselves.
What are you trying to get?
Well, when I was doing criminal defense for the clinic here at Syracuse,
Yeah.
and while we were representing a client, I would often try to get the police records and documents, and they would never give it.
From the court?
Yes.
From the court? If it's filed with the court, you should have been able to get them. And as journalists, you should all know the name David Bookstaver. David Bookstaver is pretty much the guy who deals with the news media for the Office of Court Administration. If you want his number, I can give it to you.
Yeah, sure.
Yeah, it's area code 212-428-2500. And he has no hesitation about getting in touch with the court and saying, wait a minute, court, what are you doing? What are you doing? If it's there, generally speaking, you have the right to get it. Okay? Yes, you had a question.
Yeah, just about child custody.
Child custody.
Yeah, is that consumer information?
Are you talking about a court proceeding, or are you talking about records in general?
Records.
Well, again, the records, that falls under the umbrella of matrimonial proceedings. And the records are confidential under Section 235 of the Domestic Relations Law, if you're taking notes. And also, for what it's worth, where the issue does not involve a court, but let's call it a social services agency, and the issue involves dependent children or neglected children or abandoned children or foster children, there's a statute within the state social services law which essentially forbids disclosure unless either the county commissioner of social services says it's okay or a court orders disclosure. Most, for what it's worth, and maybe I should step back, I'd like to think that our freedom of information law is based primarily on common sense. All it really says, all it should ever say, in my opinion, is that everything is open unless disclosure would hurt significantly either somebody in terms of an invasion of privacy or the government in terms of its ability to do its job well on behalf of the public, or on occasion, a private company vis-a-vis its competition. So often the question is, what would happen if the government had to disclose? And unless the answer in the gut is, ouch, this would really hurt, disclosure should be the rule. And that is so in most access laws. And again, just to put this in perspective, we have people from Colorado, Arizona, Vermont. Every state in the U.S. has passed some sort of access to records law, some sort of an open meetings law. There is also, as many of you know, a federal Freedom of Information Act. That is sort of the grandfather, if you will, of access laws in the United States and to some extent in the world. The Federal Act was initially passed in 1966. It was completely revised in 1974 on the heels of Watergate, a scandal. And I often ask this question, anybody remember the last time a presidential veto was overridden by Congress? It hardly ever happens. Well, in 1974, President Ford vetoed the amendments to the Federal Freedom of Information Act. His veto was overridden by Congress. That is how serious the Congress and the public were about guaranteeing some sort of reasonable right to know what the federal government is up to. And that opened the floodgates. Within 10 years, every state in the U.S. had enacted some sort of an access to records law, some sort of an open meetings law. And I started getting inquiries from here and there around the world pretty much in the late 70s. But the floodgates didn't open until the fall of the Iron Curtain. Today, depending upon who's doing the counting, there are approximately 90 nations that have enacted some sort of access to information law. They're all different, but the general thread in, let's call them the more sophisticated statutes, is just what I mentioned before. Everything is available except. That is the basis of access laws. If you're interested in the state's open meetings law, it's the same presumption. Meetings of government bodies have to be held open to the public unless there is a good reason for closing, unless there is a basis for entry into what is called in New York an executive session. So that is, I hope you leave today with the general notion that freedom of information law is based largely on common sense. What would happen if we had to disclose? And I have to tell people in government over and over and over again, embarrassment is not one of the grounds for denying access to records. It's not one of the grounds for closing a meeting. Yes?
So I asked you at lunch about Pat Tillman, and we mentioned the embarrassment as being a main reason for that cover-up. But then another...
You used the word cover-up, yeah. Is that
right.
One word or two? I'm not so sure.
Anyway. But, yeah, one of the other reasons it was advanced for that was that it was going to really hurt Marine recruiting. Is that hitting the gut to the...
That's what I call the malarkey principle of law. Okay. It's malarkey. Okay. It is absolutely malarkey. You know, people don't enlist because maybe they don't think that the war's a good thing. Maybe they don't want to be killed. But then again, there are a lot of people out there who still love the notion of going out there and being a soldier. My guess is that the Marines probably have not had a difficult time recruiting. The Army has had a more difficult time. You know, who was it in some campaign? I guess it was Al Gore, who said that, the Army is attracting, let's say, call them the lower levels of society, and he was roundly criticized for that. Who doesn't believe that that's not true? Who doesn't believe it? All he did was tell us what we really know, but in some cases are unwilling to admit. But in the Pat Tillman situation, how many of you don't know what he's speaking of? Pat Tillman was a football player, a great football player, and he decided to enlist in the Marines, and he was killed in Afghanistan. And we found out after the fact that he was killed by means of friendly fire. And of course, the U.S. government covered that up for a time. And a lot of people became upset, and I think for good reason. Now, that was a situation, in my opinion, where there was no good reason for withholding, other than the likelihood of embarrassment. You had a, yes?
We talked at lunch about records that are unclassified after administration's change.
Yeah.
Is there any putting the genie back in the bottle? Are there reclassification efforts that happen in a following administration, even though the documents are out in the world?
Yeah, that's going on now. That is going on now. In Albany last Friday, a symposium was conducted, and one of the speakers was the newly designated U.S. archivist. And he indicated that one of the primary goals of the National Archives is to engage in a declassification project. How old do you think the oldest classified records in the United States are? I know this because I teach at Albany Law School, and I raise this issue about classification fairly frequently. The oldest classified records deal with troop movements during World War I, and they are still classified. They are still classified. There are records that are classified dealing with the well-known dangerous dissenter during the Vietnam era, John Lennon. Lots and lots of records remain classified. Some have been declassified, but the fact is that there are dozens of federal agencies that have the ability to classify records. But there's no particular standard that is applicable across the board. That is something I believe that the National Archivist is attempting to do. Another point, yeah. You are inquisitive, aren't you?
Hey, trying to participate.
Good.
What kind of harm would be done? Why are these John Lennon records still classified?
It's lunacy. Why are the records classified? Why are the records classified? That is exceedingly hard to answer. And for what it's worth, let me distinguish New York from, let's say, the federal government. In Washington, we've all read it, we've all heard about it, where the federal agency stamps it, classified, top secret, confidential, whatever it may be. And for better or for worse, they can do that. They can do that. I don't know how many of you are familiar with the Homeland Security Act. If you work for the Department of Homeland Security, who do you think among its employees have the ability to classify records? The answer is all of them. All of them. All of them. Congress was sleeping at the switch. At least that's my opinion. And I believe, too, that Congress failed to abide by what I have come to call the Aretha Franklin principle of law. Anybody tell me what that is? Aretha Franklin principle of law? Come on, yeah. That's not it. That's not it. How many of you have seen the Blues Brothers movie? Come on. Everybody's seen. No? It's one of those movies, Grossed $8, and 8 billion people have seen it. But the best scene in the movie was Aretha Franklin playing a waitress behind the counter in a diner singing, "You better think, you better think." And Congress failed to abide by the Aretha Franklin principle when it enacted both the Patriot Act and the Homeland Security Act for a variety of reasons, which we don't really have to go into. But to compare to New York, in 1979, the Court of Appeals, state's highest court, said very simply, either there is an exception to rights of access that appears in the Freedom of Information Law, or there isn't. And if there isn't, no claim of confidentiality or executive privilege or classification will enable the government to say no. So in New York, I like to think that what's public and what's not is determined by law, not whim. And we see too much whim, in my opinion, in Washington. But yes, there is an effort to declassify, I think, to make sense, based upon this notion of harm. To what extent would disclosure cause real harm? Yeah.
In New York State, is there one agency that you hear about more than others when the phone rings?
That's really a difficult question. If you're asking me which agencies are the worst? Resistant.
Requests
Well,
for information.
yeah, there are a couple of them which abide by you'll know this, the Nancy Reagan response. Do you know the Nancy Reagan response?
Just say no.
Just say no. Just say no. Law enforcement agencies just don't like to disclose. State police, they don't care. New York City Police Department, they deny access without even looking at it. They don't want to go look at it. In my opinion, they are guilty of what I've come to call the sloth syndrome. Often, they don't care what they disclose. They just don't want to take the time to look for it. Yeah.
And so you're going about this and you're mentioning this,
Yes,
right?
I am.
And one of the things that's problematic about that is I spent quite a few years working as a magazine reporter in New York, and you're right, the police department
They just don't
across the
care.
board.
What's amazing, too, is the guy who sort of oversees their disclosure used to work for the Watertown Times and then the Daily News, and he's forgotten that he was a reporter. But anyway, go ahead, I'm sorry.
Okay. So my question with that, I mean, it becomes a little bit prohibitive, right, having to try and sue them to have records.
Sure
and all that,
does.
Because in this case, you mentioned if you win, they pay your lawyer's fees, and if you get to that point, but if not, then you're just stuck with these fees, and having to do that consistently becomes prohibitive. So in an instance, they are effectively prohibiting news media from having access to these records. And so I'm not okay with that. I just want to know, outside of incurring large fees, what the hell are the recourses for that?
I'm not okay with it either. Again, we write advisory opinions. Sometimes they listen, sometimes they don't. But for those of you who are journalists or aspiring journalists, some of you, and lawyers too, may remember the statement made by Judge Louis Brandeis in 1913. I'm paraphrasing. Sunlight is the best disinfectant. I really believe that to be so. And that's where the news media, I think, plays a particularly important role. That's why they call me. Again, they call me for the quote. Why? Why? Because often when we shed light on whatever the situation might be, either bad things stop happening or good things begin to happen. We see it all the time. I understand your frustration, and certainly people are frequently frustrated, but then again, often it's pretty hard for the government to turn down the New York Times or the Washington Post, or at the local government level, the newspaper of record in a small community. And the news media, I think, plays an immense role in, number one, letting the world know what's going on in terms of its government. Number two, avoiding being intimidated when most people will be. Here we are in upstate New York, and anybody ever been to a school board meeting? Do you think a lot of members of the public go to school board meetings if it's 10 below zero in February on a Tuesday night? Probably not. Often the only person who is there is the local reporter, and it may be a reporter from the daily or a weekly. Often it's a weekly newspaper. And the mere presence of that person has an impact on compliance with law. And I've suggested to reporters 1,000 times, if you believe that the board is about to close the meeting for a reason that can't be justified, I think it's that person's job to get up and say, wait a minute, board, this is what I call the Tracy Chapman principle. Anybody know Tracy Chapman? Come on. What's the best song of the 90s?
Fast Car.
No, not Fast Car.
Okay, ask us
Come
questions
on.
and shoot down our
Baby,
answers.
just give me one reason, and I'll turn right back around. Yeah. You get up and you have your little handout, and on page 14 you have the list of the 8 grounds for closing a meeting, and you get up and you say, board, here are the 8 grounds. Please tell me where this fits. And realistically, most members of the public won't do that. I would hope that a member of the news media will. Now, there are some editors who believe that if the reporter gets up and does something like that, that he or she is involved in making the news.
Right.
Huh.
Or missing the deadline.
Yeah, whatever. I think that if that person doesn't get up and do it, the public will miss information maybe forever that should be in the public domain. But that's just my belief. Anyway, there are steps I think that can be taken short of going to court in an effort to, let's say, enhance compliance with law. Questions? Yes.
A few years ago, 60 Minutes sent a researcher to Syracuse to review the newspaper stories and the court reporters in regard to a political investigation. And his judgment was that the Syracuse newspapers are engaged in a conspiracy to prevent the citizens from knowing the truth. Does your office receive, the inquiries you receive from Onondaga County, are they any different in type or quantity from...
I don't keep track. I don't keep track. When the phone rings, we pick it up. Often I don't know where somebody is calling from. But in my experience, and I've dealt with the Post-Standard, the Herald Journal, when it was the Herald Journal, for years and years and years and years and years, I don't believe that there is a conspiracy to preclude the public from getting information. As a matter of fact, particularly within the past several years, my belief is that the Syracuse newspapers have become more aggressive in attempting to acquire information from the government and use the Freedom of Information law than they had been in the past. No conspiracy. Where does 60 Minutes come off saying something like that? It's just plain silly. No. It's just plain silly. And, most reporters, how many of you want to be reporters again? You're a kid. Reporters don't have political agendas. They just want to do their jobs. And again, acquire the information that is needed to tell the readers what's going on in whatever the community might be. Can I digress for a moment? Please? This involves what I've come to call the love letter syndrome. Anybody here ever get a love letter? Tell the truth.
Email.
Every day, yeah.
From someone else.
Well, what does the average person do when he or she gets a love letter? That person reads it over and over and over again, reads in every conceivable shade of meaning, she's laughing, may remember it until the day he or she dies. Well, what happens when the average person, which includes the average local government official, sees his or her name in the newspaper? That person reads the article the way most people read a love letter. They read it over and over and over again. They read in every possible shade of meaning. They remember it for an awfully long time. And often, if the reporter got 95% of it right, 5% of it got wrong, a tone they don't like, a misspelling, the instant reaction is, I knew that reporter was out to get me. And again, the truth is, the reporter is a kid from Arizona, is 23 years old, has no political agenda, just trying to do his or her job. But the person who sees his or her name in print, they remember that for years. On the other hand, the average reader, because we are so bombarded with news and information, will likely forget about it in practically no time at all. And my suggestion to local government officials especially is that if they see their names in print and they don't have the words murder or indictment next to them, it's good news. It's good news. Anybody here ever seen your face on the tube? Yeah, no? It's even sillier. I do, lots of TV, and I'm a walker. I took the bus for 25 years. People would stop me. Hey, Bob, saw you on TV the other day. I always ask them the same question. Well, what did you think about what I said? Oh, I don't know what you said, but you look good. You look marvelous, It's what I've come to call the diddly principle. That don't mean diddly, and and people tend to associate fame and virtue, no matter how fleeting the fame may be, and it's just plain silly. It's just plain silly. You know, there's only one person who has ever cared about seeing my name in print. Guess who?
Your wife.
No, my wife. My mother, you know. She'd read an article, it's 24 paragraphs, my name is in the 23rd, and she'd say, oh, Bobby, there's a story about you. Ma, it's not about me. It's not about me. But mothers are all, you know, a little nutty, right? Right? You know, how many of you have seen your byline in print? God, your mother loves it, right? Yeah. It was a question someplace.
You know who liked it even better?
Tell me.
My wife.
Your wife? My wife. You know, once upon a time, you know, if I was doing something on the tube and, you know, we said to my kids, would you rather watch Daddy, would you rather watch He-Man, you know, or Sesame Street, or whatever it may have been? The choice was clear-cut. Not even close. Yeah?
I remember your committee being in charge of advisory opinions for freedom of information and open meetings
Yes.
from way back, but
From way back.
personal privacy protection law,
Yes.
how did that come under your umbrella of responsibility?
Well, it was somewhat symbolic. The Personal Privacy Protection Law was enacted in 1984. For those of you who remember the novel 1984, Big Brother is Watching, the New York Civil Liberties Union pushed for passage of that law. Then, that law deals solely with personal information maintained by state agencies, number one, and number two, to figure out what state agencies either must disclose in the nature of personal information or might have to withhold. You have to engage in circular reasoning and go back to the Freedom of Information Law, which is why it made sense to put oversight of that statute in the same office as the agency that would oversee the Freedom of Information Law. Does that answer your question? Does that make sense to you? Yeah. We could talk about privacy a lot too, yeah.
How did that change or add to, I mean, it's sort of another thing that's folded into your mission. Did it have a qualitative change associated with it?
No.
Or was it just kind of more of the...
No, it was more of the same, and it doesn't apply. The Personal Privacy Protection Law does not apply to local government. And we were talking at lunch, there are probably 10,000 units of local government in New York. When you think of cities, counties, towns, villages, school districts, fire districts, public authorities, there are thousands. On the other hand, there are perhaps, depending upon who's doing the counting, maybe 100 state agencies. And it is only the state agencies that are required to abide by the Personal Privacy Protection Law. And at the state agency level, generally speaking, they have professional staff. They have a clue what to do. We develop model procedures. It has not been a huge issue. There have been, I would guess, less than 5 lawsuits that have dealt with the Personal Privacy Protection Law since its enactment in 1984. So, more questions? Okay, let me look at my outline. I have this outline here. I want to make a couple of points about what I consider to be crucial elements of our Freedom of Information Law, which distinguish our law, I think, from others around the country and around the world. As we look at Freedom of Information statutes, they all deal with access to records. But many of them don't define what a government agency record is. As we look at the Federal Act, it has never really or clearly defined what a federal agency record might be. And to this day, there are issues that percolate through the federal courts, which involve who prepared it, where did it come from, is it official, what is its function? Those issues were all resolved in New York by 1978. And the truth is, when we were drafting what amounted to the current version of the law, at least in terms of its structure, in 1977, we could not have predicted the future. Think about 1977. Can you think about 1977? No. You guys can't think about 1977. It's before most of you were born. High tech was an electric typewriter. We used carbon paper to make copies in our office at the Committee on Open Government. Does everybody here know what carbon paper is? Tell the truth. You know, when I speak to undergrads, the most they know is that, you know, it's the stuff that makes you dirty. Nobody envisioned the internet. Huh, how many of you have laptops in front of you? Inconceivable. How about email? What the hell is email? Nobody would have known in 1977.
Al Gore
And,
did.
huh? Al Gore did, yes. Well, you know, he was a special person. And how do you have a phone without a cord? Science fiction, come on. Impossible, impossible. So again, we just didn't know, nobody did, what the future would bring. But it was the beginning of, I suppose, the era of information technology. And none of us had PCs on our desks because there were no PCs in 1977. But government and others were beginning to use computers. And since 1978, our law in New York has defined the term record expansively to mean any information in any physical form whatsoever, kept, held, filed, produced, or reproduced by, with, or for a government agency. So clearly it includes the 8.5 by 11 sheet of paper. It also includes the content of the database, email, videotape, whatever it is that is maintained by or for the government constitutes a government agency record that falls within the scope of rights conferred by FOIL. Yeah.
That sounds super broad. So
It
that
is super
covers
broad.
almost everything. But then in the reader reading, the court, citing federal precedent, said that an agency is not required to follow a path not already trodden.
Right.
That sounds pretty broad too.
Well, the point is that FOIL pertains to existing records, number one, and number two, that actually relates to an important, but I think little-known element of FOIL. And you see the same language in the Federal Act. And I'm guessing that things are going to have to change. Part of this talk involves the future. FOIL says that when seeking records, your job is to reasonably describe the records. Reasonably describe. What does that mean? Essentially, the state's highest court has said two things about that standard. Number one, the volume of the material doesn't matter. What does matter, though, often is the nature of an agency's filing or record-keeping retrieval system. If an agency has to go through the haystack in an effort to find the needle, even if the agency knows that the needle is there somewhere, the request would not reasonably describe. Let me ask you, you live in Onondaga County now?
Yep.
Yeah. Let's say that somebody walks into a government office and sees the Onondaga County phone directory and says, aha, a government agency record. What's your last name? You can lie if you want.
We met.
We met?
We met.
We met. O-U-I-M-E-T. I hereby request all the listings in the phone book pertaining to those people whose last name is We Met. Now, what if there are 10,000 We Mets? The request would reasonably describe, because that's the way the phone book is written. Last name, alphabetical order. Again, even if there are thousands of We Mets, it would be a perfectly valid request. First name, Jeremy. Huh, not an uncommon name. Same person walks into the same office the next day and says, you know, I like the We Met part. Now give me all the listings pertaining to those people whose first name is Jeremy. What? The request is specific. You know that there are Jeremys there, but you can't find them unless you go through thousands of listings one by one. That's when the agency would say, sorry, we maintain this grouping of records by last name in alphabetical order, not by first. We're not required to go through the haystack in an effort to find the needle.
At the same time, though, you could just broaden your search, right?
Let me go further. You could. But let's say that it's 2010. And let's say that the agency maintains the same record now electronically. Huh. And somebody can sit at the keyboard and enter a query, and all of a sudden, now you can pull up all the Jeremys. Well, under FOIL, based upon judicial decisions, as well as amendments to the law that have been enacted within the past few years, if the agency has the ability to do that with reasonable effort, yes, it is required to do so. So that definition of the term record, coupled with our advice, judicial interpretations, amendments to the law, has made FOIL usable. We have accommodated changes in technology that relate directly, in my opinion, to that absolutely critical definition. One of the difficulties, however, is this. Let's say that it's a more difficult request, not in terms of finding the stuff. Let's say, anybody here familiar with the Trooper Gate scandal? New York State? Nobody knows.
Just over there?
In Albany.
Oh, the thing with the governor.
Yeah, the thing with the governor.
Oh, yeah.
Let's say that there is something like that, and I'll give you a better one. There was a guy who works for a state agency who was found to be making $94,000 and was given nothing to do. Well, you know, that was reported by the news media, and of course, lots of people wanted to know more about this. $94,000 going for, you know, absolutely nothing. Well, a request came in, and the request involved all of the email communications within the past 3 years that include the name so-and-so. Well, we can find them now. We can find them. Because we sit at the keyboard, and again, or whatever it may be, the search mechanism, our search engine, enables us to locate, in that instance, 28,000 email communications. And they didn't just involve the name we met, or Jeremy. They might have involved many pages per email. So under FOIL, it would seem, based upon what the Court of Appeals told us in 1986, yes, that would be a valid request, that would reasonably describe the records. But what about the burden now imposed upon agencies? Should agencies be required in that kind of situation to read thousands and thousands of email communications, line by line, to determine which portions of those records are accessible, which portions might justifiably be withheld? I don't know what the answer is, but I can tell you that that is an issue that is ripe for study and for legislation. Actually, I'm having my class at Albany Law School deal with a variety of issues relating to so-called e-FOIL, electronic FOIL, and that's going to be an element of their final exam. Write me legislation. And they're probably in a better position to do that than I am, because after all, I'm old, and they've lived with the technology since they were little kids. I think they'll have a better clue than I will. So, questions about that? The definition of the term record. Anybody here go to a branch of the State University in New York? Where'd you go? Geneseo. When you went to the bookstore, the cafeteria, was that run by the Auxiliary Services Corporation?
No, the bookstore actually was a private business.
Private business?
Yeah, but the dining hall.
And the private business contracted with SUNY Geneseo, right, to do what it needed to do. Well, there was a case that dealt with exactly that, where records were requested from the bookstore. We want the book lists, a competitor to Barnes & Noble, actually. And it was very interesting. They said, we're a private company, we don't have to disclose. And then the applicant for the records went to SUNY, and SUNY said, we don't have them, we don't have to get them, go away. Well, the court looked at the relationship, the contractual relationship between the state university and X, and said, X, you are maintaining records for the state university, therefore they are the university's records, even though they are not within the physical custody of the agency. Yes, they are subject to whatever rights exist under FOIL. So the location of the records, based upon that definition that we've just been talking about, doesn't really matter. Again, if the information exists in some physical form and it's maintained by or for an entity of government, FOIL applies. FOIL applies. For what it's worth, in that case, the Court of Appeals said that the competitor, could not have the records. Why? Think about a gut test. Barnes & Noble spent lots of time and effort and money getting in touch with every professor to develop the book lists. So a competitor comes along and says, we want the book lists, and we want them, under FOIL for practically nothing. Well, one of the exceptions in FOIL says that government can withhold insofar as disclosure would cause substantial injury to the competitive position of the commercial enterprise. So the court said, on the one hand, yes, these are records that fall within the framework of FOIL, but no, you can't have them because an exception applies.
What is that exception called? Hardship or something?
I call it the so-called trade secret. Yeah.
The same sort of situation happened at my undergrad at university, and
which was?
Oakland University. It's in Michigan.
Okay, and I have no idea what the Michigan access law says.
They did it under the federal one, I think.
No, the federal wouldn't apply to Oakland.
Maybe it was the state, but anyway, the competitive bookstore that did it, and they went to court and they won, and they had to disclose everything they had, and they undersold them for like.
So do you think that makes a hell of a lot of sense?
Worked for me.
It worked for you because you got the books more cheaply. But, you know, was that other company put out of business?
No.
You know, sometimes we look at what's fair, what's reasonable under the circumstances. And from my perspective, I thought, for those of you who like baseball, I thought the Court of Appeals hit the corners. Yeah, you know, yes, FOIL applies, but no, you can't have it because of the harm that could arise by means of disclosure. More questions? Let me, yeah.
Under the definition of agency, at the end it says except the judiciary or the state legislature.
Right.
So they've exempted themselves.
The state legislature?
Right, from the application.
Yeah, funny thing about the state legislature, they don't pass laws unless they can do pretty much as they see fit with their own stuff. Now, the state legislature is subject to FOIL, but in a different provision. Instead of saying everything is available except, as the law applies to the state legislature, it says these things are available to the exclusion of everything else. Go figure.
Is that a common practice in other
Yeah,
states?
Congress is not covered by the federal act. It's not uncommon at all. And it involves this silly notion of separation of powers. I think it's silly because I don't believe that disclosure has anything to do with the legislature's capacity to legislate. But, you know, I lose that one, I suppose, because the state legislature does pretty much what it wants. Our state legislature, if you don't know, works in strange and mysterious ways. What do we have, just 5 minutes?
Yes.
5 minutes. I want to talk about one of the exceptions. It's my favorite. It says that government can withhold when disclosure would result in an unwarranted invasion of personal privacy. Anybody know what that means? Nobody knows what it means. Nobody will ever know what it means. There isn't a judge alive who's in a better position than any of you, assuming that you're reasonable people to make judgments about privacy. I like to use an example these days which has nothing to do with FOIL. Anybody here ever see the Victoria's Secrets ads on the tube?
Watched last night.
Yeah, yeah. Would they have aired 20 years ago?
I don't think so.
I don't think so either. Well, gee, why are they airing now? It seems that the sensibilities of society have changed. What used to be perhaps so intimate or off color that it wouldn't have been shown on network TV, but now it's on, you know, every night. Second, think about this. Two equally reasonable people can look at the same items and disagree. I use my own life as an example all the time. We used to have a joke in the house: if the phone rang after 9 o'clock, it was either my mother-in-law or a reporter who'd gotten kicked out of a meeting. Reporters call me a lot at work, but sometimes they call me at home, at night, on the weekend. It doesn't bother me. It's part of the job. My name, my home address, my home phone number are in the phone book or the white pages online. Anybody can get them. My wife, on the other hand, uses a different name. She'd never put that name in the phone book with a home address and a home phone number. Why? 2 reasons. First is painfully obvious. She doesn't want to be associated with me. I can, it's not that funny. Second, she's a psychotherapist. She doesn't want her clients calling her at home, knowing where she lives, knowing that she's married to me, knowing that at certain times of our lives it seems that we just have too many kids. She has perfectly good and valid reasons for saying no, never. And never the twain shall meet. And a third reality is that, you know, there are generational differences in the way we look at the world. For those of you who participate in Facebook, which is probably everybody, you tell the world all kinds of stuff about yourselves that just, you know, people in my generation wouldn't tell anybody. So what do we do about privacy? Well, the Court of Appeals has gone off in 2 directions. Number 1 involves records that identify ordinary people. And the Court of Appeals has said, react from the gut. Remember this from torts? What would the reasonable person of ordinary sensibilities feel about disclosure of this item? Is it one of those things where you'd say to yourself, this is offensive, this is nobody's business? Chances are pretty good. In that situation, the government can say no. The other branch of case law, which is especially important to journalists, involves people like me, government employees. And the courts have pretty much said two things about our privacy. Number one, we public employees have less privacy than anybody else. Why? We're supposed to be more accountable than anybody else, right? The public is stuck with us till the next election, till budget cuts, in my case, till retirement or death, whichever comes first. I'm eligible for both, but we'll leave that alone for the time being. Yeah, it's true. It's true. Second, more importantly, in a variety of circumstances, the courts have said, in essence, that those items about public employees that relate to their duties are public, because disclosure in those circumstances would result in a permissible, not an unwarranted invasion of privacy. And in New York, just as an example, you can find out the gross wages of any public employee in the state, from the dog catcher to the governor. You can find out, for example, if I am found to have engaged in misconduct, and there's some sort of a determination to that effect or an admission. It's public. It's public. There are lots of things that we can find out about public employees that I can't find out about you. Questions? What do you want to know about public employees? Come on. Yeah.
Well, why don't you think people know more about what it is that they can look up in terms of public records? You know, I think people would like to know these things. But
I like to think that more and more people do know something about their rights. For one thing, the news media, I don't know if they do this in Syracuse. I hope that they publish what I've come to call the top 10 list. Who are the top 10 wage earners employed by Onondaga County? Top of the list is never going to be the county executive. It's almost always going to be the undersheriff, who put in 8,000 hours of overtime last year, who was paid $173,000. People get upset when they read that. Is that embarrassing? Yes. Is it an invasion of privacy? Yes. But is it an unwarranted invasion of privacy? No. And it tells us something about government decision-making. Onondaga County, does it really make sense for you to allocate public money in that way? Gee, wouldn't it be better to put 5 25-year-olds out on the street doing what cops are supposed to do than having this old cop sitting behind a desk drinking coffee and eating donuts? Those are reasonable questions, and I think that they're completely valid. But in response to your question, I asked earlier, how many of you have heard the term foil? Quite a few. Lots of New Yorkers know foil. And it's a noun. I submitted a foil. It's a verb. I foiled such and such. It's transitive and intransitive. The government says we were foiled. It's even become an adjective. Is this foilable? And I hear this all the time. And sometimes somebody will call and they'll say, I submitted a foil, and I foiled this, and I foiled. I'll ask them, what does foil stand for? I don't know. It just means that I can get it. As far as I'm concerned, that is the goal. That is the goal. Having lots of people with a basic notion that, yes, government records routinely have to be disclosed. So I'd like to think that there are lots of people in New York, anyway, who do have some awareness that, yes, there is a general right to gain access to government information. Does that help you? Maybe not so in Arizona. I don't know. I don't know. The other, yeah.
We are now out of
We're out of time. All right, all of you have the equivalent of our handout. It has our phone number, our address. Anybody want my email address? You can have it if you want it.
Can I call you at home?
I'm not going to give you my home number. You're going to have to look it up.
What is your email?
Email address, robert.freeman@dos.state.ny.us.
Repeat.
robert.freeman@dos.state.ny.us. If you become journalists in New York, you will call. When you become lawyers, if that's what you want to do in New York, and you have anything at all to do with government, yeah, you'll call or you'll use our website. And with that, I hope that this has been interesting, enjoyable, entertaining, educational, and I thank you.
Thank you.